Welcome back to the deep dive. We're continuing our journey through the MPEP, the Manual of Patent Examining Procedure. Our mission, as always, is to really unpack this guide for U.S. patent examination.
Yep, and today we're digging into a very specific part, Chapter 2100, that's patentability, and specifically Section 2147. It covers biotechnology process applications, but, and this is important, only under pre-AIA 35 USC 103B.
Pre-AIA, okay, so right away we need to flag this. This isn't about the current system, the first inventor to file stuff.
Exactly. This is purely for applications examined under the old rules, the Pre-America Invents Act framework. So we're looking back, historically speaking, at a specific provision.
Got it. Pre-AIA, before March 16th, 2013, for most folks, and it's specifically for biotech processes. So what was the big idea behind this pre-AIA Section 2147? What problem was it trying to solve, really?
That's a good question. Basically, pre-AIA 35 USC 103B created a special statutory exception. It was an exception to the usual rules for determining if something is non-obvious.
An exception how?
Well, imagine you had a biotech process. Maybe the steps themselves, look pretty standard, nothing revolutionary. But if that process was used to make something like a new protein or cell line, a composition of matter that was genuinely new and non-obvious,
Okay.
then this section, 103B, allowed the process itself to also be considered non-obvious. But only if certain conditions were met, of course.
Ah, okay. So it's like the inventiveness of the final product could sort of pull the process along with it, patent-wise, even if the process steps weren't groundbreaking on their own.
Exactly, you've got it. It was a way to potentially secure patent protection for the method when the real inventive heavy lifting was in the thing being produced. Back when biotech was really taking off, the novelty often was the molecule or the organism itself.
Right, that makes sense. Maybe the thinking was to encourage people to patent those methods too, even if they used known techniques to get to a novel result.
Precisely. It likely aimed to provide a clearer path, maybe a more certain path, to patent protection for these related processes, encouraging investment in the whole biotech endeavor.
Okay, so interesting historical context. But given that it is pre-AIA, firmly in the past for new applications, why should someone listening today, maybe studying for the patent bar or just trying to understand current practice, care about this specific section?
Well, a couple of reasons. First, if you ever deal with older patent applications, ones filed before the AIA fully kicked in, this could still be relevant. You might encounter it.
Okay, legacy cases.
Right. And second, it's crucial for patent bar exam prep. The exam definitely tests pre-AIA law, so you need to know about things like 103B. Plus, honestly, understanding how the law evolved, seeing these kinds of specific exceptions, gives you a richer understanding of why current law is the way it is. It shows how patent law adapted to new tech like biotech.
That's a good point. Context is always valuable.
Right.
So let's say someone was back in the pre-AIA days and wanted to use this 103B exception. It wasn't just automatic, right? You mentioned cadditions. What were the specific boxes they had to tick?
No, definitely not automatic. There were several key requirements. First off, the process itself and that novel, non-obvious composition of matter it produced or used, they had to be disclosed together.
How so?
Either in the very same patent application or, alternatively, in separate applications, but those separate applications had to share the exact same effective filing date. So a really tight connection was required right from the disclosure stage.
Same application or same effective filing date. Got it. What was next?
Ownership. This was strict. At the exact time the process was invented, not later, but at the time of invention, both the process and the composition had to be owned by the same person or company. Or they had to be under a legal obligation to be assigned to the same entity.
Wow, okay. So ownership had to line up perfectly at the moment of invention. That seems quite specific.
It was, and yeah, for the nitty-gritty on assignments, you'd look at MPIC Chapter 300, and Chapter 400 covers applicant definitions.
Right.
But the point is, common ownership at the time of invention was crucial for 103B.
Right. What else? Disclosure link, ownership link.
Then there was the claim linkage in the patent itself. The patent that issued had to reflect this connection. It either needed to have claims covering both the process and the composition of matter.
Within the same patent document.
Yes. Or the patent claiming the process had to be linked to a different patent that claimed the composition. And if you went that second route with two separate patents, they absolutely had to expire on the same date.
Ah, the double patenting angle. Makes sense. You don't want to improperly extend the patent term by having related process and product patents expiring at different times.
Exactly. That ties into the whole doctrine of double patenting, which is covered extensively in MPP Chapter 800, specifically Section 804.
Okay. Disclosure, ownership, claim linkage. Was there anything else needed to invoke 103B?
Yes, one more key step. The applicant had to actively elect to use this provision. They had to file a formal petition under 37 CFR 1.182 saying, hey, we want to proceed under 103B.
So you had to raise your hand, essentially.
You did. It wasn't something the examiner would just apply. And, like most petitions, it involved paying the required fees. You can find those in MPP Section 1.17 and following the proper petition procedures outlined elsewhere in the MPP.
Okay, so a conscious, deliberate choice requiring specific actions. Now, the section title specifically says biotechnology process applications. How narrowly was biotechnological process defined? Did just any method involving biology count?
No, definitely not. The definition under 103B3 was quite specific, quite narrow, actually. It wasn't meant to be a catch-all for any life science process. The MPP gave some clear examples of what qualified.
Okay, examples are always helpful. Let's hear them. What kind of processes fit the bill?
Well, one major category was processes using genetic modification techniques. Think recombinant DNA technology specifically to alter the expression of a nucleotide sequence. So making a cell produce a protein it wouldn't normally make or changing how much it makes.
Right, manipulating genes. That sounds core to biotech.
Absolutely. And this area, connects directly to the rules around sequence listings, how you have to formally present DNA or protein sequences in an application. That's covered way over in Chapter 2400 of the MPEP and various related rules and international standards.
Okay, genetic modification for expression. What else counted as a biotechnological process under this rule?
Another key example was cell fusion procedures, specifically ones used to produce particular proteins. And the classic example given is making monoclonal antibodies, fusing different cells to create a hybrid that pumps out the antibody you want.
Monoclonal antibodies, yeah, hugely important. So genetic engineering, cell fusion, any other types?
Yes. The definition also included methods of using the products that resulted from those kinds of processes. So if you made a novel protein via genetic engineering, a method of using that specific protein could also potentially qualify under 103B, assuming, again, all the other conditions were met.
Interesting. So it covered making the thing and also using the specific thing made by those biotech methods. Could you maybe walk us through a slightly more concrete example just to see how it might have actually worked in practice?
Sure. Let's imagine a company invents a brand new therapeutic protein. Totally novel, clearly non-obvious. They get a patent on the protein itself.
Okay, standard product patent.
Right. Now, they also developed a specific method to get genetically engineered yeast cells to produce this protein efficiently. Maybe the method itself, the steps of growing the yeast, inducing expression. Maybe those steps use techniques that are generally known in the field of yeast fermentation.
So the process might look obvious on its face.
It might, under the standard 103A obviousness analysis, but if that protein product is novel and non-obvious, and if all those other under 3B conditions we talked about are met, disclosure, ownership, claims, the petition,
All the hurdles.
all the hurdles are cleared, then this specific method, using this engineered yeast to make this specific novel protein, could be deemed non-obvious under 103B. It really shows that tight linkage the statute created between the process and the non-obvious product.
That example makes it much clearer. Thanks. Now, you mentioned earlier, and the MPP points this out too, that relying on 103B is actually expected to be pretty rare now. Why is that? What happened?
Well, the landscape shifted, mainly due to some key court decisions from the Federal Circuit, specifically cases called In re Oki and In re Brower.
Okay, Oki and Brower, what did those cases say?
Essentially, these decisions affirmed a broader principle. They basically said that a process, even if it uses conventional steps, can still be patentable, non-obvious, if it's directed to making or using a product that is itself non-obvious.
So the courts kind of established a more general rule that achieved a similar outcome to 103B, but without needing that specific statute.
Pretty much, yeah. These rulings essentially said, look, if the only reason you're doing this otherwise standard process is to make or use this non-obvious thing, the process itself can derive patentability from that non-obvious thing.
Right.
This arguably reduced the need for applicants to rely on the very specific conditional pathway offered by 103B.
Interesting. The courts sort of caught up or provided a different route to a similar result. So if these cases lessened the need for 103B, why do we still have Section 2147 in the MPP? Why keep talking about it?
Because it's still part of the legal history, and crucially, it was the law applicable to potentially many thousands of applications filed before the AIA. So for practitioners dealing with those legacy applications, maybe involving issues like priority claims, continuations, divisionals, or even double patentee arguments related to those older cases, understanding the specific rules, like 103B, that were in effect then is vital.
Right, you need to know the rules of the game as it was played when those applications were filed and examined.
Exactly. And as we mentioned, for anyone studying for the patent bar, pre-AIA law is fair game. Understanding concepts like 103B isn't just about passing the test, it deepens your grasp of how patent law evolves and adapts, especially in complex areas like biotech.
That makes a lot of sense. You get a better feel for the why behind current practices. Okay, so let's try to sum this up. What's the main takeaway message regarding MPP Section 2147 and pre-AIA 103B?
The core idea is that pre-AIA 35 USC 103B offered a unique conditional pathway. It allowed certain biotech process claims to be considered non-obvious if they were tightly linked to a composition of matter that was itself novel and non-obvious. You had to meet several strict conditions to use it.
And while court decisions like Oki and Brower provided a broader principle that lessened its necessity over time,
it remains important for understanding the historical context, for dealing with any pre-AIA legacy applications you might encounter, and definitely for patent bar preparation. It's a key piece of the biotech patent history puzzle.
Okay. And thinking about that history, here's a final thought for you, the listener, to chew on. How might this specific pre-AIA approach, this idea of explicitly linking process patentability to product novelty in 103B, have influenced how we think about patenting processes in biotech and maybe even other fields today? Did it shape later developments? Something to consider.
Definitely. And as always, we encourage you to explore the related MPP sections we touched on: assignments, applicant definitions, double patenting, priority, continuations, sequence listings, petitions. It all connects.
It does. And before we wrap up, we absolutely need to give special thanks to Mike Shepard. He's the creative director who organized and directed this whole audio project, making this deep dive series possible.
Yes, a huge thank you to Mike for his vision and effort on this.
And finally, the necessary disclaimer. Please remember that this summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM. While we strive for accuracy, it might contain errors or omissions. It's provided for general educational and informational purposes only. It is absolutely not legal advice or a substitute for formal instruction.
That's right. For any authoritative guidance, you really must consult the official MPEP itself, talk to a qualified instructor, or seek advice from a registered patent practitioner.
Thanks for joining us for this deep dive.